Hi family, I have been directed by our mentor to deliberate on appeal before Appellate Tribunal. So friends, a dispute arises once we file our return and they are being scrutinized by the jurisdictional officer. When he finds some defect in the return, he issues notice either in the form of ASNT 10 or DRC 1, a show cause notice. There are three more agencies which have a continuous kind of observation on your activities. They are Intellivision, Audit, and DGST Intelligence. So the dispute starts from issuing of the ASNT 10 notice and or SCN, show cause notice. So you are required to give your reply within a time frame given in the notice and on the points as specified in the notice. So once you have filed your reply, that will be considered by the jurisdictional officer first, and if it is found that he is satisfied, the matter will be closed here itself. If not, he will pass either a reasoned order or a vague order. That reply filed by the taxpayer have been considered but was not found tenable. And that's why the demand is raised. So that is a vague order, that is not reasoned or speaking order. When you will go in first appeal or thereafter, that you can make your defense on the basis of this vague order, because this is not a speaking or a reasoned order. Once your claim has been rejected, then you will be required to file appeal before the first appellate authority. And here any aggrieved person, the main emphasis is that any aggrieved person from the order passed by the jurisdictional officer can file an appeal under section 1071 before the first appellate authority. You have to give a paper book before the first appellate authority, starting from the show cause notice, your reply and order of the jurisdictional officer. In case you rely on any case law, so you can enclose the copy of order of the case law passed either by the any high court or supreme court. If he is satisfied with your submissions, then he will also close the matter, or he will pass a very unreasoned order saying that he has not given any additional evidence. So friends, you have to remember that the evidence, the facts, the circumstances will remain right from beginning till end, same. So if he calls for that no further evidence has been given, so that is considered as a vague order and you can contest upon it in the next appellate authority. So when he has rejected your claim, he has raised the demand, so then you will be required to file appeal before the GST Appellate Tribunal. See, GST Appellate Tribunal has been established now. They are under preparation and very shortly they will be operating, because all members, judicial, technical and president, they have been selected, they have been allotted their branches and they have been advised to join before on 21st of January, and the process is on. Very shortly it will be operational. Now the detailed procedure of filing an appeal lies here. The aggrieved person here, the word is not agreed. The person, the registered person against whom this order has been passed, he will file an appeal before the tribunal in a prescribed format, that is APL 5. And when you will file the appeal, that the required time will be 3 months from the date of communication of order to the taxpayer by the first appellate authority. And further it can be, the delay can be continued for 1 more month. But that is not your right. That is depends on the circumstances and the appellate judges. Anyway, but try to file it within the prescribed time limit of 3 months. Say if the order has been passed on 1st of July, so July, August, September, 30th September will be the last date to file appeal before the appellate tribunal. Once you file the appeal, a provisional receipt in the form APL 05 will be generated, and that will be the proof of filing the appeal. Now you have to prepare 4 sets of the paper book, starting from SCN, your reply before the jurisdictional officer, then you facts and grounds of appeal filed before the first appellate authority, and his order, your memorandum of appearance, power of attorney, and any other document which you find relevant for substantiating your claim. Now, after preparing these, there may be 3-4 more options before you, that you may need to get adjournment, or you have to file some additional ground before the tribunal. So if you have to file additional ground, so there are 3 circumstances under which you will be allowed to file additional ground. They are, first, that this ground was denied by the first appellate authority, or you have filed that ground, but he has not considered it while framing the order, appellate order against you. And third was that a thing which is relevant for getting you justice could have to be procured from some other agency, and you could not procure it beyond your limitations. So under these circumstances, if the judge is satisfied, he will allow you to file additional ground. And so far as adjournment is concerned, the adjournment will be given only 3 times. You can seek adjournment, preparing a application, giving extensive all circumstances which has led to you seek this ground, maybe health ground. Yes, an application, affidavit, and if it is based on the health ground, then you have to enclose the medical certificate, and you can get only the adjournment can be given only thrice, not more than 3 times. Now, once this appeal is admitted, there is APL 5, APL 02, facts of your case, grounds, filed before the first appellate authority, your submissions, your memorandum of appearance, and thereafter you will be given an opportunity to appear before the court. Then it mandates a separate decorum which has been specified in the GST Appellate procedure rules. the appeal has to be accompanied by a fees which is 1,000 rupees per 1 lakh of the additional demand. But and minimum fees is 5,000 rupees and maximum is 25,000. Remember that whatever the demand which is accepted by you has to be deposited in advance and enclose the challan along with your paper book. The filing fees of the appeal is different, and the filing fees for the appeal is different. Now, after you are given a chance, so yes, you have to deposit 10% of the disputed demand. The admitted demand has to be deposited along with interest under section 40, and when you file the appeal before the tribunal, additional 10% of the disputed demand also has to be deposited. So friends, once this appeal is admitted and you are given an opportunity, then you will be called to appear before the court, the tribunal. So, who can appear before the tribunal? This has been defined, the authorized representative has been defined in section 116 of the GST Act. He may be either the appellant himself, his relative, permanent employee, a practicing auditor, practicing advocate, chartered accountant, cost accountant, or company secretary holding a valid certificate of practice, and the certificate has not been debarred from practicing. When you will appear as a chartered accountant, as a authorized representative, you have to maintain some decorum of the court. Your dress code would wear the all matters at the time of your hearing. And once you enter the court, you have to calmly wait for your turn. When you will be given opportunity, you have to stand, say, "Good morning, sir. I am CS so-and-so, appearing on behalf of ABC and Company Limited. With your permission, I am taking the opportunity to advance my arguments." And all, you have to brief your factual matrix, grounds, and enclose, argue only on the basis of your cause only. Dumping any irrelevant material will not get you substantial justice. Thereafter, your government counsel, the departmental representative, will be required to advance his argument. So you sit calmly and hear what he says. Once he completes his argument, and if you again want to counteract his arguments, so calmly stand and say, "Excuse me, sir, give me one more opportunity to deny the argument of my learned friend, the departmental revenue council, and counteract whatever you want precisely on the facts, on the grounds of your own cause, no irrelevant type of thing, and say that is all my submission is, and definitely you will get substantial justice if you deserve. Thank you very much.